Thank you, Ms. Mattson. The court recognizes the Honorable George Lewis on behalf of the state. Sir, is there an amount of time you would like for me to let you know that you have remaining?
I have a 5-minute warning.
Yes, sir. You may proceed whenever you're ready.
How much time do I have?
You have 45 minus 12 is 33. You have 26 minutes until your warning. Go ahead.
All right, thank you. May it please the court, counsel. Ladies and gentlemen of the jury, good afternoon. On behalf of the District Attorney's Office, citizens of Dallas County, and most importantly, this family over here, the family of Genevive Dawes, we want to say thank you first and foremost for your time and your effort. It's been a week. You've heard a lot of testimony, seen a lot of evidence. And we know that you don't take this case lightly due to the magnitude of it. So first and foremost, thank you. Thank you for your time and your attention. When Mr. Mitchell got up here in his opening statement, he told you what they were going to say. He told you that the defense attorneys were going to get up here and say that they deserve it. They put this defendant in the position to use deadly force. They caused all of this. Mr. Prosecutor says, if he didn't want to do this, but they put him in this position. The defendant was a Dallas police officer tasked with answering calls and dealing with incidents that come up on a day-to-day basis. If he didn't want to be in this situation, and if he didn't want to deal with it, don't be a Dallas police officer. Nobody asked you to sign up for this. That's what you're supposed to do, but you're also supposed to follow the law. Police officers are not exempt from following law, just like you and I. The laws of self-defense, defense of third persons while using deadly force, that applies to him and other police officers just like it does us. They put him in this position. Okay, I'm not getting up here and saying that we condone the actions of Ms. Dawes that night. Stolen vehicle, stolen gun. Obviously, we don't condone that. But at the end of the day, you cannot use deadly force because somebody's in a stolen vehicle. Okay? You can't use deadly force and shoot and kill somebody because they have a gun in the car, even if it is stolen. Especially when that information comes to light after the fact. Now, the defense gets up here and harps on the fact that there's a stolen gun found inside this vehicle. Okay. Yes, officers don't know what's inside this vehicle, but each and every officer who testified on this stand for you under oath this week told you that gun did not play any decision, any factor whatsoever in the use of deadly force in the situation. That gun was found after the fact. Even the lead detective, Dale Richardson, got up here, swore to tell you the truth on this stand, told you about all the experience that he has, and he told you that gun did not play any factor whatsoever in the use of deadly force. Again, what you're tasked with deciding is at the moment in time this defendant used deadly force against Ms. Dawes, was it immediately necessary? So take the gun, set it aside. That's not what you're here to decide today. And as pertains to the actions of Ms. Dawes as she operated that motor vehicle tonight, I told you in opening statements that you'll get to see this particular shooting from many, many angles based upon the 5 officers who had on body-worn cameras at that time. And you got to see that for yourself. They want to get up here and say that she was desperate to get out of there. She was willing to do anything, including mowing over officers. Is that really what you saw in that video? Is it really? I asked those officers if she really wanted to run over some officers, she could have gunned and pressed that gas to the floor. Could she not have? Of course she could have. And we're talking about ramming this vehicle. Is that really a ramming? Really? I think what we pointed out, and you guys understand, is that this defendant, Mr. Hess, got into that squad car, pulled it up, okay? The vehicle comes on, the reverse lights actually come on before he pulls up, and as he pulls up, she pulls back, okay? And the vehicles collide. But that's a random. And if you also recall talking about credibility and somebody lying, he says on the radio they ran the squad car twice. Well, we saw that wasn't true. You see, you get to judge his credibility as well. And that's part of it. So let's kind of start at the beginning. Let's start with Mr. Samples. He told you that he recognized this vehicle from the day before. It's approximately 10:30 the morning before when he observed this vehicle. He looked inside, he saw Ms. Dawes and Ms. Gonzalez sleeping inside this vehicle. They had on a leopard blanket and they were sleeping inside this vehicle. Okay? That's what he testified to. He was concerned, called the police. Police got there and they responded. Now, Officer Alish, let's start here. Let's talk about the tactics that the officers used. Everybody described how this is such a dangerous situation. We don't know what's going on with this vehicle. We have to be cautious. We have to be vigilant. So we pull up the squad car for cover, right? That squad car is there to cover us just in case somebody starts shooting outside this vehicle. But that's not really what we saw in the video. You're looking at a screenshot from Officer Hopkins' body-worn camera, State Exhibit number 4. Okay. This is right after Officer Hopkins goes up and pulls the car door on the car. Right? And this is such a dangerous situation that we're going to walk right up to the car, even though the squad car is here. We're using it for cover, right? That means you get behind it. No, they're right up on the vehicle. He pulls the car door down. Talking about Officer Alish, why we didn't call him, again, credibility. Y'all saw his demeanor on this stand yesterday. He tried to tell you that when I made the statement, okay, it's occupied, they're sleeping. I have no idea why I would have said that. Maybe I was relying on what the call sheet said, or I don't know why I would have told officers that. So my question to him was, isn't it important for officers on the scene to have all the information? For you to be as accurate as possible so you can relate to the other officers what's really going on this extremely dangerous scene? Well, yeah, I would agree that that's important. But again, I don't know why I would have said that. Well, I submit to you he said that because it was true. It's occupied. They're sleeping. He's looking right inside the vehicle. They're sleeping. How do you know they're sleeping? When Mr. Gonzalez gets out of the vehicle, there's that leopard skin blanket that Mr. Samples told you about. And we saw him sleeping the day before. The seats inside the vehicle are reclined, consistent with them sleeping inside the vehicle. Okay? So, they're sleeping inside the vehicle. At some point, we know that they hear the commands of the officers because they started the vehicle. Let's talk about the manner in which she is operating this motor vehicle. Again, the defense wants you to believe that she was totally desperate to get out of there, and she would do anything to get out of there. But what do we see on the video? Let's start with this. Discharging firearms at a moving vehicle. Straight out of the Dallas Police Department General Orders 906.02. Discharging firearms at moving vehicles. Discharging firearms at a moving or fleeing vehicle is prohibited unless it's necessary to prevent imminent death or serious bodily injury to the other officer or another person. Officers will not voluntarily place themselves in a position in front of an oncoming vehicle where deadly force is a probable outcome. When confronting an oncoming vehicle, officers will move out of his path, if possible, rather than fire at the vehicle. Straight out of the BPD General Orders. So let's talk about what some of these officers said. Officer Erin Evans, what did she tell you at the moment in time this defendant decided to use deadly force? She did not see a threat when the vehicle reversed the second time. That's what she told you. She told you that she expected the other officers to move out of the way of the vehicle. As they're instructed, as they're trained, as they're required to do under the general orders. And that's exactly what she did. That's exactly what Officer Alice did. That's exactly what Officer Liquar did. That's exactly what Officer Hopkins did. That's exactly what Officer Kemple did. And that's exactly what this defendant did. They all moved out of the path of the vehicle. She told you she did not know why the shots were being fired. Again, because she did not perceive a threat at that time. There was testimony about, again, officers not knowing where everybody else was at the time. And that's accurate. But again, immediately necessary. You cannot fire on possibly, you cannot fire on probably. If you're not sure whether or not there's an officer over there, you don't fire. It's as simple as that. Mr. Mitchell said it in his statement. Again, he may not have known that they were over there, but he sure knew that they were not over there. He surely knew that they were not over there again, because based upon those general orders, they're not supposed to put themselves in the path of the vehicle. Officer Liquar, what did he tell you? The vehicle did not pose an imminent threat while it was backing up the second time, because he could see that there were no officers immediately behind the vehicle. He told you that. He expected the other officers to move out of the way of the vehicle, just like Officer Evans testified to. Officer Hopkins did not shoot because the vehicle was not coming at him or other officers. The vehicle was not being used as a weapon when it hit the fence. The vehicle was not being used as a weapon when it reversed the second time because there was nobody behind it. These are the facts.
Hey, what's up, guys? Any around like security that are uniform? Don't move!
If you saw and paid attention, as she begins to back the second time, the brake lights are being activated. You can see that she's being very careful when she backs out of that parking space. Besides the fact that you know at this point, based upon this testimony of Mr. Johnson and Mr. Partain today, that that vehicle was going at a max of 3.1 miles per hour walking speed, you know that she's being careful. First of all, based upon the video evidence, as well as that's consistent with what Mr. Sackler said on the stand. He said that when I saw that vehicle back and I saw the brakes activated at least one time. And that's what you just saw in this video. Not only that, the medical examiner testified that gunshot wound number 1, the exit of it, is consistent with a re-entry into the entry of gunshot wound number 3. Not only that, but it's consistent with someone who's turning to look backward if they're backing. So you have the gunshot wounds that are consistent with her turning, looking to see what's behind the vehicle. You have the speed of the vehicle, 2.5 to 3.1 miles per hour, walking speed. You have Mr. Samples telling you that the brakes are being activated, and you have the video evidence showing you that the brakes are being activated as she's backing the vehicle. Now ask yourself, based upon all this evidence, is that someone who is desperate to get out of there, to run over officers, to cause destruction of property, and to go all out to get out of the situation? I would submit to you that it's not. Going back to these officers' positions, and Mr. Mitchell stated this as well, based upon the video evidence, Mr. Hess is telling the officers, move back, move back. And now we can see on the videos that you have 3 officers to his right-hand side. You have Officer Liquar, who's on the passenger side of the vehicle. You have Officer Evans, who's on the passenger side of the vehicle. And you also have Officer Alish, who's going towards the backside of the vehicle. And so who is he talking about? Get back. Those officers are in a position of safety as well as he is. He's talking to Officers Hopkins and Kemple, who were behind the vehicle. Yet the defense wants you to believe he's in such a situation where he's in this mindset of this tunnel vision, where he has narrowed his focus so much on this vehicle that he can no longer see what's going on. But he's talking to these officers, telling them to get back, which is exactly what they did. Now let's talk about this tunnel vision for a moment. The defense would have you believe that this tunnel vision causes you such where you're not aware of your surroundings anymore. Right? Mr. Priest testified that yes, there is such thing as tunnel vision. It does affect your peripheral vision. However, that is not an excuse. That does not excuse you to go all out to use deadly force in any situation. Think about that for a second. They're saying that his peripheral vision is cut off such to the fact that he can use deadly force without having a reasonable belief. In other words, I'm so focused on this right here that I don't have to take into account what's behind the vehicle, what's in front of the vehicle. I can fire indiscriminately at that point because I have tunnel vision and I'm so focused on this. That's not appropriate, and that's not right. Again, based upon the law, immediately necessary, based upon the circumstances that were given at that moment in time. Officers are trained to consider their target and their background. Okay? Again, based upon the evidence in this case, they cannot see inside this vehicle. They told you that many a time. Why? Because the windows were fogged up. So when you're considering your target and your background, you have to consider other occupants of the vehicle. You have to consider what's in front of the vehicle, what's behind the vehicle. But he didn't do any of that, because if he did, he wouldn't be here today. He wouldn't have fired his gun. Because based upon the video evidence, Officers Hopkins and Kemple had moved well before he decided to use deadly force in this case. Again, going back to the speed of this vehicle. Focus on Officers Hopkins and Kemple.
Back up. And you're around the like security that uniform and arm. Don't move!
You don't need an expert to tell you that a vehicle going 3 miles an hour can cause 6 bodily injury or death. You don't need somebody to come in here with a bunch of degrees and tell you that. Okay, it's obvious that if you're in the path of the vehicle going at that speed, if you're laying down or you're not paying attention, it can harm you. That's not the issue in this case. The issue in this case is whether or not the defendant used vigilance to determine whether or not it was immediately necessary in that situation to use the deadly force. And we know that based upon the evidence, he didn't. Okay? He had ample time to either look in the direction of where the path of the vehicle was going. If he would have did that, he would have saw that there were no officers back there. He didn't have to turn his head, peripheral vision. Take a quick glance over there, and you see that there are no officers behind the vehicle. No other officers besides him and Kemple fired shots. And they told you why they didn't, because they didn't perceive the threat. Let's talk about Officer Kemple and his shot. He shot one time. Based on the physical evidence that we brought you, we were able to prove to you that his shot did not hit the victim, okay? It lodged in the door frame of the vehicle.
Then I would object that's a misstatement of the evidence. The witnesses, in fact, stated that they didn't know who shot.
Members of the jury, you'll recall the evidence as you see fit. Go ahead.
April Kendrick testified that the bullet that was taken from the frame of the vehicle matched his gun. John Priest, our use force expert, testified that it is not normal. It's not usual for an officer to shoot one time. They're trained to double tap and reassess. So I asked yourself, why did he shoot one time? Well, the explanation for that is very simple. Sympathetic fire.
Judge, I'm going to object to that. The evidence is from Kimple's mouth is the reason he didn't fire but one time is that Hess, he could read the name on the back of his jacket, and that's why he didn't fire.
Right.
He had to that twice.
The objection is overruled. Members of the jury will recall the evidence as you see fit.
Sympathetic fire is where something stimulates you and you have an involuntary reaction to it. Let's talk about Kimball's testimony. He told you that he stopped firing because he felt as though the defendant was in front of him and he didn't want to fire on him. Go back and look at the video. I ask that you do look at that. If you look at his actions after he fires that one shot, his firearm stays trained on that vehicle as it goes backwards, and he actually tracks it. The defendant didn't move 1 inch, but he's telling you that he stopped firing after one shot because the defendant was right in front of him. Again, credibility. You have the right to judge each and every witness who testified in this case based on what they told you on this witness stand. It's based on their demeanor. It's also based upon what they told you, whether or not it made sense. And I will submit to you what he told you about that one shot. Did not make sense. Police officers are trained that they are to be responsible for every single round that comes out of their firearm. Every single round. They have to be justified. Again, based upon the general orders, you're not supposed to be firing inside moving vehicles. Your first thing to do is to move out of the path of the vehicle. And each and every officer testified that they expect the others to do something. And that's what happened in this case. The defense talks about, we don't want you to have the truth. That could be farther from the truth. Let's talk about Mr. Rosales. I asked Detective Richardson, based upon the statement that Mr. Rosales gave to detectives in this case, was it consistent with the information and the evidence that you gathered during the course of your investigation? The answer was no. Why would we present a witness to you like that? Why would we present a witness to you that's not going to be truthful? We wouldn't do that. Let's say you were trying to hide Mr. Rosales. We're trying to hide Detective Embry with the Sheriff's Department who did this speed analysis. Well, let's talk about what Detective Embry did. I asked Mr. Johnson, did you review these calculations that Detective Embry did? He said, yes, I reviewed them. Well, what did you think of them? They were totally inaccurate, totally wrong. The methods that he used were incorrect. He basically used his visual eyes to look at a screen, looking at the video, and he used a stopwatch to do the time. He went out to the scene, he took a tape measure, and he measured the panels on the fence to do distance. Again, it's not accurate. Defense counsel told me that his numbers were twice the numbers that Mr. Johnson and Mr. Partain came up with using methods that are far more exact and far more specific and far more reliable. That's why we didn't call Detective Embry. But they want to tell you that we're trying to hide evidence. The defense counsel says that the defendant used deadly force because Ms. Dawes was out of control that evening. She was going to do anything to get up out of there, including running all the officers, which you didn't see on the video whatsoever. And that he was going to stop her before it was possible that she hurt anybody that night. Again, there's that word, possible, probable, next step, next course of conduct, next course of action. Again, the law doesn't work that way. whether or not it's immediately necessary at the time that the deadly force is used. Think about this. And we do this every day. Think about pulling out of the parking space at the grocery store. Pulling out of the parking spot at the mall as you get ready to leave. If this conduct by the defendant that day was acceptable, exemplary, as the defendant lawyer would have you believe, then we're all in trouble. Because in that particular situation, somebody can use deadly force against you. And that would be considered acceptable. I will submit to you that that's not acceptable by anyone, let alone a Dallas police officer who's tasked with protecting and serving. Again, we don't condone the actions of Ms. Dawes that night. Okay? Situation where, again, police were called, should have been police contact, some investigation should have occurred. It's possible she could have went to jail that night. But again, disobeying an officer's commands, fleeing in a motor vehicle, does not give cause for a Dallas police officer to shoot and kill anyone. And if today by your verdict, you say not guilty, you're saying that conduct is acceptable in our society. I said in my opening statement that again, we here at the DA's office, we work with good, hard-working police officers every single day. The majority of them do great work. They follow the law, they do their job, they go home at night. But in this situation, with this defendant, the manner in which he used deadly force on Ms. Dawes, the manner in which he disregarded all the information that he had at that time.
You have 2 minutes.
Thank you. The manner in which he shot 12 shots into this vehicle. First, a volley of 9, a break, no reassessment, no looking over to make sure that nobody's behind the vehicle, and then 3 more shots, hitting her multiple times and killing her. Not to mention, if he actually really reasonably believed that there were officers over there, and he's putting bullets toward them as well, talking about considering your target in the backdrop. Again, not reasonable. I'm going to ask you to find him guilty of this offense today. Again, your verdict today of guilty is not a message to all officers that we don't support you, because we do. Your verdict of guilty today will send a message that this particular type of conduct would not be accepted in our society, and he needs to be held responsible for his actions. We're going to find him guilty. Thank you.
Thank you, Mr. Lewis. You may be seated. Members of the jury, I'm going to send you back. It'll be a few minutes, but we will get all of the evidence that was admitted to you for all purposes as soon as we possibly can. To the alternate juror, I'm going to have some additional instructions for you right now. Please don't discuss this case with anybody else. Please let me know if anybody approaches you, if anybody talks to you, makes you feel uncomfortable for any way. Let the court know through the bailiffs who have you in their charge. I'm going to talk to you further about ways that I can get in contact with you and have some additional instructions about where you're going to be while the jurors deliberate. Members of the jury, you are only allowed to deliberate when all 12 of you are present. Please mind the instructions that I've given to you. Good luck during your deliberations. All rise for the jury. Mr. Lewis, Ms. Madsen, can I see y'all very briefly? Thank you. Court's in recess.